My lord, the court is not audible.
The court didn't say anything to be audible. The petition is allowed the order of the tribunal in application number so and so and the transfer order dated 14/8/23 issued by the first respondent are hereby set aside. The petition shall be reposted to Vijayapura district within a period of 3 weeks from today. We've also held that this judgment is rendered only on account of lack of reasons informing the transfer, and it will be open to the competent among the respondents to pass valid orders of transfer after recording proper reasons for the same, if warranted.
Grateful.
Please.
We have noticed that the present transfer is to a nearby place, and the tribunal has taken note of the fact that no inconvenience or grievance has been pleaded or proved. Having gone through the files produced by the petitioner, we also do not find any material to substantiate the contention that the transfer is vitiated by malafide or is only intended to favor the private respondent. In the facts and circumstances, we are of the opinion that the reasoning and order of the tribunal cannot be faulted. Should petition fails, same is accordingly dismissed.
Great.
Yes, sir. You wanted to submit something? No. That is all. Okay. Yes. Transfer.
But the matter pertaining to transfer by order dated 28/8/2023, the petitioner was posted as registrar, Karnataka Ayurveda and Unani Board. Annexure A2, my lord, page 73 is the order. Lord, pursuant to that, my lord, I made a representation requesting the government to issue a movement order. Lord, transfer order is issued. But one government has to issue a movement order so that I can take charge. But on 31/8/2023, the second respondent writes a letter to the respondent number 1 that, my lord, petitioner is not senior most medical officer and therefore he cannot be posted as registrar. Lord, the draft C&R rules is published, which does not speak about the seniority. It says that, Lord, it is by way of deputation from the cadre of physician grade 1. It is a draft recruitment rules. Lord, since they did not issue a movement order, I approached the tribunal. Lord, the tribunal disposed the application, directing the Lord state government to consider the representation and to pass appropriate order having regard to the Lord health condition of the petitioner. Lord, my lords will find the order at page 96, annexure A7.
Yes.
Page 100. The application is disposed, page 100. Application is disposed of, directing the respondent 1 and 2 to consider the representation submitted by the applicant at annexure A3 and A4, requesting the authorities to issue movement order in pursuant to the order dated so and so by considering the health problem and so and so. Again, I made a representation pursuant to the order of tribunal. Not on 2011-2023, page 110. The second respondent writes a letter to the first respondent to take decision in the matter. But movement order is issued. Finally, my lord, on 22-12-2023,
Sorry.
22-12-2023, page 113,
Yes.
I am posted as Registrar, Karnataka Ayurvedic and Unani Board, Bangalore. The competent authority to effect transfer is the state government. State government has passed an order, state government has issued a movement order. But despite that, second respondent writes a letter on 26-12-2023
Yes.
that petitioner cannot take charge as a registrar. Pursuant to that, my lord, 1-1-2024, this is the impugned order before the tribunal.
Yes.
Lord, the earlier transfer order dated 28-8-2023 and movement order dated 22-12-2023 are withdrawn. And Lord, I am posted on OOD to Karnataka third respondent authority. Karnataka Medicine Plant Authority, Bangalore. But this order was challenged before the Lord Tribunal. Lord, mainly on the ground that Lord, competent authority is the state government. State government has transferred. State government has issued a movement order. Second respondent, my lord, cannot say that, my lord, I cannot take the charge. The recruitment rules says that, my lord, it does not speak about the seniority.
You said draft.
Draft CN.
Not approved. Rules are not approved as yet.
It was a newly created post.
It is a newly created post,
Approved.
not approved. My lord, if it is for the first time, draft can be operated. My lord, in the case of,
Correct. It is
Yes.
I asked. Not approved, but newly created.
it is newly created post. Draft rule is
Yes.
page 91 is the rules, the recruitment rule. It says registrar by deputation of an official in the cadre of physician grade 1 Ayurveda from the department of so and so.
Okay.
Therefore, my lord, question of seniority does not rise. The objection raised by the second respondent with regard to seniority does not rise. Twice I have been posted there. No, my lord, despite that, my lord, the order is withdrawn and my lord, I am posted there.
What is the direction?
Please, my lord.
How was it dealt with by the tribunal?
My lord, tribunal says, yes, my lord. Tribunal's finding is at, my lord, page 43, annexure A.
Yes.
But reasoning starts from para 5, page 49.
Yes.
It says that, my lord, tribunal cannot direct the government to implement the transfer order. And there is no extraordinary circumstances. And I cannot be permitted to choose a place. On that ground, my lord, tribunal has dismissed my application. May I read, my lord, the para 5? Upon considering the submission made by both the sides, it is clear that applicant being medical officer at Government Ayurvedic Hospital, Panchavalli, Periyapatna Taluk, and in view of liver transportation and
Yes. Liver transplant.
yes. But competent authority,
There appears to be some reference to your eligibility.
yes, that is, my lord, seniority, my lord.
Yes.
Seniority is not the criteria. But may I request my lords to kindly take,
Now, what is the finding of the tribunal on that?
there is no finding, my lord. There is no finding.
Tribunal mainly proceeds on the footing that because of his health condition, he has to be posted to a place where it suits his health condition. But the position of the government is there are two cadres, my lord. One is medical officer and senior medical officer, and this is a sole post in the entire state, and this post actually requires traveling throughout the state, and therefore, in fact, the government is not proceeding in a confrontational manner in this matter. They have proposed three posts actually, out of which he has been given uh, the post at the third respondent authority. There is also a post available before the central pharmacy, government central pharmacy, which is also in Bangalore. So, which is a very, my lord, I'm told that he did not want to go there because he was afraid of the pollution there may aggravate his problem. But this is a pharmacy where it's a very sanitized place, air conditioned, and this is not a place where it's not going to cause him any problem. It's not going to aggravate his medical condition. Therefore, my lord,
According to you, it is only.
we are only trying to help him, in fact. But this post is not available for him, my lord, because the senior most in the next cadre is supposed to, my lord, this is being a new post. The policy is being worked out as to who should be the appropriate person to man this particular post. My lord. Therefore, there may be some, my lord,
Transferring. Is it your contention that it is when he alerted you as to the health condition that you became aware that he may not be the fit person to be posted there?
Indeed, my lord, that was also one of the considerations. That was also one of the considerations. The government is indeed trying to help him, my lord. They have been offered him 3 separate posts. And the KT also dismisses the application on the ground that he has no right to seek a particular post. No employee has the right to seek a particular post as held by the Supreme Court in Bhattacharya's case.
But before that, my lord, government has sought for consent of the petitioner, which is at, my lord, page 66. It is the, my lord, permission given by, my lord, page annexure A1, page 67. I extended my consent.
My lord,
But
the,
based on that, my lord, an order was passed on.
the nature of the post
28
may be taken into account, my lord. It requires traveling.
But thereafter, my lord, on 28/8/2023, government transfers me. But I requested for movement of issuance of movement order.
Role of the second respondent.
Not absolutely, my lord, second respondent, insofar as this post is concerned, he has no role to play. State government, my lord, appointing authority, disciplinary authority.
State government is the appointing.
He is meddling.
Second respondent, my lord, who is no way connected to, my lord, posting, is intermeddling with the, my lord, posting, and on that ground, impugned order is
But
passed.
the matter has been listed for the first time. This is the instructions I have, my lord. My lord, and having regard to the fact that the post requires him to travel, this is a single post in the entire state, my lord. And it requires traveling. And having regard to his medical condition, he has been offered 3 different separate postings. I mean, he can choose, even now he can choose any of the 3 posts available.
What
Which are
state
in
is saying
Bangalore.
is They are more concerned about your health.
From 2023. All this did not work.
Lord,
Apparently, the order was passed on 26/12/2023. I mean, 22/12, the order was passed. 26/12, the objection comes up. The rules don't appear to say anything.
Not twice orders are passed.
Is in effect, you
My
will
lord,
be
it
right.
may be noted that he requires traveling. I'm submitting on instructions. It may be recorded, my lord. If I'm making, if they are making any wrong submission, if
That's
the
that.
nature of work does not require him to travel,
Lord, I have
having regard to his
Lord,
medical condition.
I have taken instructions, my lord. As far as the registrar is concerned, my lord, it does not require any travel. But I have taken instructions.
Then I will get back on this point,
Get
my lord,
instruction.
whether it is really requires traveling or not.
Yes.
Not one sub,
Only that, not only that. What is the role of the?
Role of second respondent, I'll find out.
not they are likely to, my lord, post somebody. Lord, if it is posted, my lord, writ petition will become infructuous.
Not any posting shall be subject, maybe made subject to outcome of this. writ
But
petition.
again,
If
he,
there-
he should be read as a party, my lord. Because of, my lord, my health condition, my lord.
No, any order will be made subject to outcome of the writ petition.
We list it on Wednesday.
Please.
In the meanwhile, are you sure that nothing will happen?
No. Lord, it may be if any posting is given, it may be made subject to the outcome. And accordingly, if any posting is given, it will be so recorded in the order itself. So no equity can be claimed.
Lord,
Done
in
with
that
the
event, my lord, A14 may be stayed, my lord.
For the respondent seeks time to get instructions in the matter. List on Wednesday. It is made clear that any posting to the post of registrar in the so-and-so made registrar Ayush. In the meanwhile, shall be provisional and subject to further orders in this writ petition.
Lord,
Yes, Wednesday,
in the,
will do.
but in the same stage, my lord, once,
No, that is the.
but once notice is ordered, my lord, it will.
We go to BB, that is all. But then
None of your case will be in B group.
this is one consistent
No.
argument that you have in all your matters.
It's only on those two issues.
This is the only issue, my lord.
Because I'll
Yes,
assist the court on the next occasion.
Here for petitioner. Matter pertains to regularization.
for driver,
Yes, ma'am.
you've been given the benefits of the other act.
Other acts.
When were you
Similarly
appointed
situated
where?
person. My lord. Very similarly situated person has been granted same relief for regularization. My lord. Only petitioner is denied the benefit by the tribunal. My lord.
What does the tribunal say about that?
My lord, petitioner is not working against sanction post. That is. My lord. I may be shown.
Was that you were
Is
appointed
reg-
against a sanction post?
His
My lord,
regularization is not retrospective. It's not
No, not
Subject to correction.
retrospective. Retrospective.
Regularization Not grant.
Retrospective, when applicant petitioner is completed 10 years, more than after 10 years, petitioner is entitled for regularization. That is the order, annexure A14, my lord. A14, page number 13. Similarly situated person has been granted from the 1995, 94, Kritika VS. I am also related to same set of acts is applied to the present
Wherein the
petitioner also.
respondents categorically admitted that D.S. Kritika, initially appointed by the Director of Mass Education as typist against sanctioned vacant post from 28/8/1984.
Yes,
Thereafter, she continued service without any break for more than 10 years based on judgment of Umadevi. The case was accepted, granted relief. Thereafter, government regularized the service of V.R. Kritika in accordance with law.
Hmm.
While comparing the case of the applicant, totally distinguished.
yes, ma'am.
Judgment is not.
Ah,
faithful.
I,
Therefore, the finding is that in your case, there is no sanction post.
yes, ma'am, I have to show, ma'am. My lord, page number 83, annexure A11. Applicant is continued in sanction post and not obtained any interim order, not continued on the basis of any court order. Annexure A11, translation copy of annexure A11, page 85, page number. My lord, this is the department information.
It does
In-
not say that it is against sanction post. Where does it say?
This is sanction post. ma'am.
It only says vacant post.
It does not say sanction.
This is
post.
comparison. ma'am. This is comparison to Kritika.
Council, it does not say vacant post, I mean, sanctioned
Ah.
post. Where does it say?
My lord, kindly come to annexure A4, ma'am. A4.
Yes.
Translation page 47. Loka Shikshana, Directorate, Director, Adult Education Officer and staff post and including 7 districts project up for the year 2004-5. Continuation. Kindly come to page number 48. ma'am. Then page number 49, order portion. 19 district and 7 new districts and state under the Jilla Panchayat jurisdiction of the Department of Loka Shikshana and belong to on various group under the belong planning director of officer of the district adult education officer. Total 126 posts as mentioned in annexure A. madam. Dated 1/4/2004 to 1/2005. Sanction for continuation of service.
126 posts
Yes.
mentioned in annexure A,
A.
dated 1/4/2004.
Yes, ma'am. Sanction for continuation of service.
Only for continuation of service, council,
No,
not
ma'am.
sanction for regularization.
No,
There's a
madam.
difference.
This is continuation service, continuation sanction post, madam.
Service you've been given.
This is continuous sanction post, madam. This is the sanction.
Is not sanction post and
Sanction
sanction
is
the
for
post.
continuation.
It is only sanction for continuation. Even so,
Same, my lord, same, on the ground of parity, my lord, same, my lord.
Parity.
Page number, I have to show another document, annexure A8, my lord.
sanction for continuation and sanction of a post are different matters.
Sanction post, I have to show, my lord.
And
My
the
lord,
post
kindly
has been
come.
sanctioned in 1984 when you were appointed.
Yes, my lord. This is sanction post.
Oh.
Kindly annexure A8, my lord. Page number 73. Page number 7, translation copy of 74, ma'am. In relation to the above matter, reference 1, wide government notification, so in 2014, identify the eligible daily wage workers of the Director of Public Education and reference to wide government so and so under the Karnataka Daily Wage Employees Act, daily wage workers who are eligible for continuation of service as per reference section 3(2) are ordered to be given minimum pay scale, leave and other facilities in the scale of post in which they were continued in service from the date notified by the concerned administrative department of the government
This
state.
you've given.
Accordingly,
Workers benefit you've
Yes,
given.
yes, he has been brought
well,
under
kindly,
daily wage
kindly,
workers welfare act.
kindly continue. Accordingly, in the Ministry of Primary and Secondary Education, so and so, following the employee director of so and so. Madam, V.S. Kritika, this is annexure A14. V.S. Kritika, appointed on 8/11/1984. Office of the District Office, working address.
Both of you were given.
I am the second, serial number 2, madam.
Council, we understand, both of you were given the benefit of the 2013 Act.
Yes, ma'am.
She, because her post had been sanctioned as on the date of her appointment on 8/11/84, she was given the benefit.
She is also given, I am also given, madam.
They're not.
I am also given 2000, both names are there, madam.
What were you given?
I am entitled for regularization, madam.
You were not. Show us that there was a post.
My lord, also to
Sanction
come to the
post.
question of whether conditions
Sanction
under
post.
para 53 are fulfilled. First of all, the initial entry should be in accordance with the constitution.
Yes, madam. I have appointed with the process of selection process, madam. Annexure A1.
Post
Yes, ma'am.
to a duly sanctioned post.
Yes, madam. That has been approved by the higher authority.
Where is the sanction for the post? Not the sanction for continuation, sanction for the post.
Sanction for continuation is under the provisions of the 2013 Act. That is to protect you.
Yes,
You get the right to continue until your normal retirement age. You also get ex gratia or the provident fund or whatever you are entitled to. It is for that purpose that annexure A8 has been passed. That nobody challenges it. You're entitled.
yes, I am
And the
entitled.
regularization, you must say that you fall within the 4 conditions in Uma Devi.
Yes, my lord, I have
In the
fulfilled.
case of Kritika, they say that that post was available. In your case, they say the post was not available.
No, my lord, this same set of acts, my lord, same set of acts, how it is,
Show us that
Discuss-
post was available.
post, yes, his post is there, my lord.
Where?
Annexure, yes, annexure A4, annexure A, my lord, page number 50. Page number 50, annexure A, translation copy. There is one post of driver, my lord,
A5,
Annexure?
50.
annexure A4, page number 50, my lord, annexure A,
Three.
tabular column. Translated copy. Vehicle driver, one post, that is sanction post.
That's for continuation. No difficulty in understanding.
Yeah, it will continue, my lord. Continue from time to time.
Are appointed, was it a sanction post? That is the question.
That is, I am a sanction, against the sanction post I have appointed, my lord.
Where is that?
Annexure A, my lord, annexure A.
What is the date of appointment?
Date of appointment 3/6/1982, 85.
We want
I
that.
have rendered 32 years service, my lord.
Understood. As on 85,
Yes, ma'am.
whether this post was sanctioned.
Yes, my
That
lord,
is the
that is sanction post. I am against the sanction post.
Where?
No,
Annexure A, my lord, A1.
but this is for 2003, 2004.
No, my lord,
Continuation.
annexure A1, page number 37, 36. 36 Kannada, 37 English. Annexure A2, 38 page number. District Adult Education Office appointed for office vehicle driver, Minuddin, and daily wages basis from 3/6 to the is approved.
Will not show that there is a sanction post. It only shows that you've been appointed.
Yes, ma'am.
This appointment will be for a period of 3 months. New appointment will be made without prior approval. Salary will be paid after approval obtained from the Director of Adult Education.
Yeah.
No difficulty, you were appointed.
Yes, ma'am.
Your appointment on 3/6/85 is not disputed by them, which is why you've been given the benefit of the 2013 Act.
Let them see, ma'am. Notice me.
Nothing wrong in the finding of the tribunal.
No, my lord.
Unless you can show us. It's not for somebody to bring something. Please show us that there was a sanction.
This is
post.
sanction post, my lord. This is, I have shown you, your lordship.
Till now
Annexure,
you have shown us nothing to show that there is a sanction post as on 3/6/85 to accommodate you.
there is earlier endorsement has been given, same endorsement has had given, my lord.
Please show
That
us,
has been challenged, that has been set to tribunal.
please show us that there is a sanction post on 3/6.
Sanction. This is the annexure A4, my lord. That is a tabular column, my lord.
Annexure A4 will not help. That is for continuance. Your continuation under the 2013. That you've been given,
My lord.
that you've been given. The continuance under the 2013 Act you've been given.
I have verified.
What do you say, Governor? Is there a post of driver sanction as on 3/6/85?
No, my lord. It's clearly says that it's no procedure. If there was a sanction post, then the procedure known to law would have been followed. There's no notification calling for inviting applications for regular appointment at all.
Now, he's been given all the benefits of the later. Act.
Yes, yes, he has been. It has been recorded, finding has been recorded by the tribunal at page 24, my lord.
How was this appointment made?
It's a casual appointment,
Normal cash.
daily wage appointment.
Next week, I will verify.
If there is nothing to show that your appointment was against a sanction post, whatever you could have been given has been given. Just because somebody else had a sanction post, that does not, unless you can show us that as on 3/6/1985, there was a sanction post. And then again, you must also show us that you were appointed after a due selection process with proper notification and advertisement.
Published,
Yes.
much.
at the request of
Any
the
date,
Government.
any date? ma'am?
After 2 weeks.
You said you are not available in the afternoon.
Fortunately, 32 is not sitting as on now. Criminal is partner. However, not probably learned judge is held up in division bench.
Therefore, we are fortunate.
I am fortunate. A petitioner, before your lordship, Lord, is appointed as a junior engineer
Sorry,
in public, yes, lady, Ashalata.
just a moment. What were you appointed as?
But initially,
as?
I am appointed as, Lord, junior engineer in Public Works Department on
Yes.
16/8/2007. Then, Lord, promoted as assistant engineer.
Yes.
Then further promoted as assistant executive engineer. In the year 2020, but three department engineers in three department, PWD, irrigation, Panchayat Raj. They, Lord, resolved the policy, Lord, to absorb certain engineers from all departments with option. With option. And they are entitled to seniority on the date of initial appointment if they opt for any department among three. But the time was extended up to 27/11/20.
To submit options.
Yes, Lord. A petitioner did not submit option, Lord, within time. She made, Lord, that option again is extended, Lord, second option by annexure D, page 48, 29/1/21. Those who are already opted, again they have to, Lord, opt whether their, Lord, option.
Is this matter covered
There
by
was-
any earlier judgment?
There was no second option, my lord, if I'm,
No, I'll show it. Second option is there.
There was
is-
no
is
second
this
option
matter
given.
Covered by
It is
any
not covered.
earlier-
It is
but
not
in
covered.
fact, they have filed a writ petition
But
against,
It is not covered, Lord.
my lord,
It is not
what has
covered.
happened is in an earlier round of litigation,
I will come to that. I have produced that order also. What happened, my lord?
state is with them, my lord, but
State is with
it
them.
seems unfortunately,
State has given seniority. Some private person questioned that order, giving seniority to who are junior to me. The tribunal quashed the seniority. Lord, I have produced that order. My lord will find that order, page 111. 111. Seniority fixed on 27/9/2022. Lord, that is annexure M, page 104, is quashed. What tribunal says is, you have not questioned the order of your absorption, which is passed in private interest on your, Lord, request.
that's
Tribunal
not,
observes it, my lord,
that's not the
page
case.
125, my lord.
Sorry, that's not the case, my lord. It was challenged by her juniors who became seniors in the
That's what peace
absorb
law.
department.
I know, I will tell the fact. If
That's
court is not, if a court is not correct, if I am correct, you correct me. But please allow me to tell the fact. Lord, the one, Lord, CH-3 and Hari Prasad, NX page 111, question, Lord, the seniority given to me under order dated, Lord, 27/9/2022. That is, Lord, page 104. 104. And DC, Lord. Page 104. My lord will find Srimati Ashalata BS, her seniority is counted in, my lord, RDPR with effect of 16/8/2007. Page, Lord.
That was set at naught.
That was set that was set at naught. On the ground, my lord, you have accepted your the absorption order dated 15/5/21, which is passed in private interest. Therefore, you are entitled only bottom seniority, etc. Then, my lord, I filed a writ petition before this court, lord. The WP 7477 is pending before this court, questioning this order. Lord, 7477 of 2024 is pending before this court. Then, my lord, when this court observed that I have not questioned the order of my absorption with private interest, I filed application questioning my lord, my absorption, foregoing my seniority. My lord, what happened, my lord? In the meanwhile, the RDPR passed a circular, my lord, annexure D, page 48, my lord, extending, my lord, giving option. And you see that. Page 49, para 2. But when it is passed,
Yes.
But,
Annexure D is dated 29/1.
yes, my lord. Extend up to, my lord, second option is concerned, up to, my lord, 20 to 21. It is extended. But I have, my lord, filed application for my lord, option on, my lord, 12/1/21. 12/1/21. That is annexure. Lord will find the C, page 45. Page 45. The government passed an order absorbing me, referring to Rule 16, Lord, page 58. Under Rule 16 of the General Recruitment Rules, page 58. English version is 59. Last clause is added, Lord. Rules, clause proviso 1 of the 6 of seniority rules would be applicable. Proviso 1 says, Lord, person who made request, he has to take seniority from bottom. This is the order. In the same fashion, Lord, there are several engineers, Lord, who opted later to me, Lord, one, Lord, Javregowda and Lord Sanjeev Kumar, Lord, they are all absorbed, Lord, in the year 2022, page 139. 139. My lord will find that order. Same order, 16 only. 139 is the order absorbing 2 engineers in RDPR, referring to Rule 6 of seniority rules, page 140. Madam. English version is also there, page 140. B.N. Gowda and Sanjeev Kumar. Lord, those 2 engineers are concerned, Lord, they have been given seniority, though they have opted much later to me, 27/10/21 and 27/21 is the option given by them. Same order is passed. Why? Because, Lord, seniority, the recruitment rules, Lord, annexure B, Lord, kindly see, protects our seniority. My lord will find page 190. 190. May I draw your lordship's attention to page 190 of the RDPR sanitation department. 190. Rule 3. Lord, got it?
Yes.
The Karnataka rural drinking water sanitation shall consist of so and so corresponding entries. My lord will find the Rule 2. There shall be constituted a service called Karnataka Drinking Water Sanitation Services within a period of 3 months from the date of commencement of the persons who are working at various ports in the Karnataka Rural Water Sanitation Department on deputation, appointed to public works, inland, Panchayat Raj Engineering, drinking water, may exercise irrevocable option for absorbing the said department by application as specified by appointing authority. Persons who have expressed their willingness may be absorbed equivalent to the post of Karnataka Rural Development Sanitation, and the inter-state seniority shall be determined with reference to the seniority and length of service. This option is extended several times. Annexure D is the last option. That is up to 29 to 22. Page Annexure D, page will find page 48. 48. But my absorption is application is 12/1/21. By annexure, under annexure D, it is very clear. But second option is concerned, they have extended up to
20th February.
Yes, Lord. 22. Lord. However, tribunal quashed my seniority, writ is pending. No, my lord, when I questioned my absorption, because it is contrary to rule, I am entitled seniority from the date of the appointment. Tribunal says, my lord, what tribunal says is, my lord, it is barred by limitation and res judicata. Res judicata. Condition, my lord, order of the tribunal, page 15. It refers to the earlier order, page 30, my lord. Condition. Because I am entitled seniority, last clause should go. That is my prayer. What tribunal says is, delay cannot be condoned, not 1.5 years delay is there in approaching the court. Tribunal says no proper reasons are assigned, delay cannot be condoned. It says further, res judicata, page 30, para 15. Subject for the application already having been determined in application number so and so, it is not open to the applicant to agitate the matter yet again in this application. Consideration of main prayer wherein effectively held that applicant is governed by proviso to Rule 6 seniority rules. Therefore, there cannot have any seniority in the respondent prior to 10/3/21, the date on which she was relieved from PWD. Is it by principal certificate? But where is the application of the tribunal referred to above, my lord, is pertaining to the private persons who filed my questioning my seniority, not my absorption. Question of res judicata will never arise because I have questioned the absorption only, last clause of the absorption. When my lord similarly situated employees in the same department have got the seniority, like me, even they opted later in my lord October 21. Sanjeev Kumar and Gowda. Lord, those Lord orders are also produced before your lordship, Lord. 14/7/2022, Annexure 2, page 139, is the order of absorption, Lord, of B.N. Gowda and Sanjeev Kumar engineers, Lord, in RDPR, same department. Kindly check my absorption order also. It is ditto word, Lord, as passed. The absorption of 13/5/2021, page 58. Kindly compare page 58 to page 140. Both are engineers. All are engineers. From PWD, they are absorbed in RDPR. No other words, same words, same fashion, same rule is referred. Why? Because the option is extended by annexure D. When I questioned before the tribunal without even issuing notice, dismissed my application. Kindly see, the annexure A is the order passed by the tribunal, page 21. And before your lordship, questioning the order of the tribunal cannot dismiss an application without condoning delay, because only 1.5 years delay is there. I explained to it. And Lord, res judicata will never arise because I have not, my absorption order is not questioned in the previous application. My seniority is questioned in application number which referred to your lordship, which is pending before your lordship.
396.
1396. 23. Those orders, I already told your lordship, writ petition is already pending. Notice is issued by this court. That is 7477 of 2024.
Yes.
No reversion order is passed. That is why I am before your lordship. Kindly, I am seeking your lordship's indulgence to stay the reversion. That's all my. Kindly now order of reversion annexure N, what tribunal says is, I mean, what, when the option extension time is given, rule will apply. Even order is wrongly passed under Rule 16 of the General Recruitment Rules, referring to Rule 6, Proviso 1. It makes no difference because all the engineers are given seniority who have opted later to me, absorbed later to me.
The earlier round of litigation, you did not have a case that the option had been, time for option had been extended.
Yes, my lord.
In the
That has
earlier
been
round-
extended up to, under annexure D, my lord, within that time I have filed. Annexure D,
Where was that contention? You did not take up such a contention in the earlier round.
my lord, is right. My lord is right.
Huh.
I have not taken that contention because that document is not available to me, my lord. It is not available to me. Subsequently it's available, my lord.
Then how
And
did
I-
you make the, because to say that it is not available at the relevant time,
Yes, ma'am.
your OA in the earlier round is filed.
No,
when-
earlier round, I have not questioned the absorption. I'm only respondent.
When
I'm
did you file
respondent
the-
there.
When did you file the earlier application? Earlier OA date?
Earlier, my lord, order. Earlier order is there, my lord.
Judgment is dated the order in the OA is dated 8/2/24.
Yes, my lord. Annexure N, I am a respondent. I cannot question my absorption.
That may be so, but
Yes.
on 27/9/2022,
8/4/2020.
what you're challenging,
Ah.
by the time all this is there, nobody has such a case.
Which one, madam? Which
That
order?
that the time for the option had been
Yes,
extended
Lord.
was the defense you should have taken in
Yes,
your.
Lord. It is not. I fully agree. I fully agree. But the question is now, when I am calling order of absorption only, last clause of the absorption.
What is the difference? That
Difference
will
is
be-
what?
consequence
Because-
Be the same.
No. Their seniority is given, seniority is quashed. I am the respondent. 13,
Seniority is quashed on the ground that you had not given option in time. Tell us how it does not operate as constructive res
no.
judicata.
order is, no, 13/5/2021 is the absorption order. That has not been questioned by anybody. I am the respondent.
Yes, therefore.
But in a collateral proceeding, my lord, where I am a respondent, my lord, can I, my lord, tribunal can say, since
Your absorption and grant of seniority to you, reckoning your option, your belated option,
yes,
was specifically what was in question before the tribunal in the earlier round.
no,
You did not have a case.
no, it is
in
not,
the
it,
earlier round.
my lord, it is not, my lord, that order of absorption is not questioned. And it is, my lord, that order of the tribunal. If I'm subject to correction.
In effect, it's the same thing.
That is true. My lord, Kandisi,
In effect, it is the same thing.
so CH-3 and NR and Hari Prasad M, they approach the Karnataka State Administrative Tribunal and annexure N, questioning the seniority given to me by,
Contention was that the last date for submitting the irrevocable options, which was extended on 4/7/2020,
yes,
was 10/7/2020.
yes, my lord.
Applicants have submitted their options. The third respondent did not submit, fourth respondent did not submit such option. However, fourth respondent submitted a representation for absorption on 12/1/2021 after the process of absorption in terms of the order dated 16/5/2020 had been completed. Fourth respondent absorbed in the first respondent department by a government order dated 8/3/21 and OM dated 10/3/21 as at annexures A11 and A12.
Yes, yes.
That specifically was the case. You did not raise a contention that there was an extension of the option on
Yes.
29/1/2021.
I did not
Till
raise.
22/2021.
Yes, Lord, I did
Therefore,
not raise.
the tribunal ruled as against you. Now, first you have to, the WPC 7477/24 will
Yes.
first have to be considered.
Yes, ma'am.
It's only if that is allowed that you will have any semblance of a case. Otherwise,
But the question is, my lord, in a collateral proceeding, my lord is right.
it is not collateral. It is challenging your seniority granted to you. Same thing. Same thing.
Seniority granted under the seniority restated 27/9/2020.
Whatever that be, this was the issue in question. Are you entitled to seniority? in the transfer department was the issue in question. The tribunal held otherwise.
Yes.
Now, unless your WPC 7477 is allowed, you don't have a case worth arguing before this court.
Subject to my lord's correction. If suppose, my lord, my absorption order, last clause is struck down, what will happen? Kindly appreciate. Because my absorption order is not questioned by anybody. But it is interpreted, no doubt. But the question is now, tribunal says, you are not, last clause in, you are not questioned it. And is the
Raise these contentions in 7477. If it's a mistake of fact, it can be corrected. These contentions you will have to raise in 7477. It will have to be considered. The judgment of the.
I fully agree with your lordship.
Have to be
Both,
corrected,
both should together, my lord is right.
be together.
Otherwise, my lord, this will come in the way, but to give a finding, my lord, because 13/5/21 order, last clause goes, I am entitled to seniority. Kindly appreciate this, my lord. Why tribunal said, your absorption date 13/5/20.
Did not challenge it at the
Right.
relevant time.
Right.
You did not challenge it at the relevant time.
Right.
When was
One-
your absorption?
13/5/21, my lord. 1 year, within 1 year. 1.5 year delay is there, not I agree. But tribunal can condone delay under section 21(2). It has power to condone up to 3 years, my lord. Kindly appreciate this.
Did you approach the tribunal for condonation?
Yes, my lord. Tribunal says no ground to condone delay. Kindly see, my lord, that also. With application, my lord, I filed. I can understand, my lord. Tribunal says, kindly see, my lord, that also. Tribunal says, para 11, page 28.
Yes. Yes. Unless
Yes.
those persons who have actually challenged your seniority,
Yes.
they also have to be heard before this contention can be considered. I still feel that it is only in 7477 that this contention can be considered. Why don't you raise this there? Your contention
My
now
lord,
is
my lord,
that it was even after 10/7/2020, there was an extension.
yes.
It has to be raised in those proceedings, not.
But the
behind.
question is, well, who will set right by the order dated 15/5/21?
First get this.
Yes, along with that, I
earlier-
agree. I fully agree with your lordship. But question is, tribunal says limitation,
Without them on the party array, we cannot touch this.
but certainly because last clause under law, but and rule 3,
If this application is allowed, it is allowed and consequently application is allowed,
yes.
it will have a consequence on the seniority of other persons who are not parties to this proceeding.
And
But-
suppose 7477.
Therefore, my submission to your lordship, both should be clubbed together. I am not saying, Lord, both should be heard and together. If my contention is accepted, I will succeed. Otherwise, no. That's all I can.
Yes, what do you say?
But just to bring clarity to the matter, my lord. In fact, there is a fault on the part of the government also. Initially, we passed an order saying that she will not get the benefit of her past service as per Rule 6. That was annexure produced at annexure G, my lord. This is the initial order. The last sentence, it is stated that the order, annexure G at page 57, my lord, in Kannada.
Yes,
The translation starts at page 59.
Hmm.
The last paragraph, my lord, the seniority of Srimati Asha Lata BS Assistant Engineer Grade 1 will be fixed as per Rule 6(1) Sub-Rule 1. It's not Sub-Rule 1, my lord, first proviso
Hmm.
of the Karnataka Civil Services Seniority Rules,
Hmm.
which says that past service, benefit of past service will not be given if transfer is at her own request transfer.
From one. department.
Thereafter, unfortunately, government has passed an order giving her seniority over her juniors who exercised the option first and joined the service.
Hmm.
Therefore, their absorption was treated as public, being in public interest, and they were supposed to be given seniority as per annexure G, but as per annexure M, seniority was given to the petitioner. This was challenged by them. This is at annexure 10, page 1, annexure M, page 104.
Hmm.
This is in Kannada. It doesn't specifically say that they have been given only because only her name is mentioned here. And
Yes.
serial number is mentioned.
Yes.
This
So
was
other
challenged.
options Were effective.
This was challenged in the writ petition, application before the tribunal by her juniors who became senior in the absorbed department. And thereafter, the petitioner has filed this appeal
Hmm.
before, which is pending before this honorable court. There is no stay order granted. Now thereafter, I believe this litigation, well, in my understanding, this,
Tell us, is it a fact that the date for submitting the options to extended further on 29/1/2021?
well, as per my instructions, they were not extended. Malad.
Annexure D.
Therefore, it was treated as at her own request.
If even suppose there is an extension, what are the terms of the absorption? Is it the first options have to be considered first and the extended option, persons who submit options in the extended time will
Malad,
be
if
considered
time
under
is
the-
extended, I think she will get the benefit, Malad, if time has been extended, because
D,
Malad, I
at page 49.
only had cursory look because my learned friend I received the copy only today. Although I gave my phone number to my learned friend, she did not serve the copy yesterday. She has served it in this one. So I received it today morning and got the instructions.
For the purpose of compliance, we got
And
just.
so far as I know, there was no extension. But if there was an extension, I have to consider that she will get the seniority from it.
The background, assistant engineer, junior engineers who are group B and C officers who are merged in rural so and so. Accordingly, in these cadres, the officers employees belonging to merged public works department service will have to submit letters of intent to continue their seniority in the local cadre or their subsidiary cadre. The officer employees opting for the local group should submit their letter of intent along with certificates prescribed in the rules. This is only for already opted officers,
Second option, madam. It is second option.
not a second option.
Kindly think that also. Second
No
option.
extension of the time given
And
to
in this background,
give up.
assistant engineer, already given option. They have already given option to absorb. But
According to the decision taken by the government regarding separation so and so,
yes,
officers, employees of the PWD will be merged with the rural department, Panchayat Raj department as
Yes.
the letters of intent submitted by such officers and as per the consent given by PWD, the other departments.
yes, yes.
In this background, assistant engineer 1, assistant engineer 2 and junior engineers who are group B and C, who are merged in the rural drinking water and sanitation department of rural development and Panchayat Raj department, separate seniority list to be maintained for local and subsidiary groups. So it is only in respect of the all persons who have already submitted their option.
Not-
An
what-
option was given either accordingly these cadres belonging to merged service will have to submit letters of intent to continue their seniority.
Yes.
Either in the local cadre or in the subsidiary.
Parent cadre. Parent cadre.
Not extension. of
This is a
the-
second option given to them. This is a second option.
Therefore,
Given to officers who had submitted their options on or before 10/7/2020.
Kindly now take
Not
page,
thereafter.
page 140, how the government interpreted that. Page 140.
This is another issue. Now we are considering whether.
Yes, yes.
Tribunal was
Not I-
right in saying that.
But I am
it is
making-
hit by res judicata.
No, I am making my submission. Why? Because interpreting that the government has given senior to all engineers who are absorbed. Now, I understand what,
Have
hello,
given wrong seniority, that will
it is
not.
not wrong seniority. Kindly see, not page 140. B.N. Gowda, but why again option, my lord, otherwise? Option is not necessary. Once I have
It is necessary because in the opted department, there is a local cadre and a residual
that
cadre.
should be given only for local cadre, not anybody.
This to be given to all persons who have opted, whether they want to remain in the local cadre or the subsidiary cadre. That is intended only for those persons
No.
who have opted.
Rule,
How I
my
understand.
lord, 371J, my lord,
Get instructions in the manual.
371J, my lord,
Whether
is
on
concerned.
29/1/2021, there was a further option given to persons who had not opted as on 10/7/2020 to come over to this department.
Please.
If that is not so, then nothing requires to be considered.
Time is extended, only to the records, so that they are the persons coming to the local government.
These are persons who are option given to persons who have already opted, who are in the country, whether they want to remain in the local government or
Subject to correction, my lord, that option is available only for 371J. Those who belong to, my lord knows, in 7 district, if they are absorbed in RDPR, they have to give their option, whether they retain in parent cadre, their seniority, or in the local cadre. It cannot be brought for 2,
What that annexure is.
but it cannot be 2.
Already the government passed an order in favor. The earlier order which was against her should superseded by this order, although it was contrary to the earlier order. So they have which went against her. That was challenged and
Challenged by somebody else.
Yes,
And
challenged.
those somebody else are on record only in WPC 7477. There we must consider,
Is totally unwarranted.
which is the finding,
Superseded by the new order which was in her favor.
My lord,
which is the finding of the tribunal.
Therefore, has to be kept. As your lordship pointed out, 2 conflicting decisions in the remedy, 2 matters are undertaken.
res judicata will, my lord, according to me, it will not apply. I will convince that no difficulty at all. But the
Anyway,
question,
we think this issue has to be,
Yes,
if you say that.
anyway,
there is
my
an
lord,
option-
right.
There is an option on, further option on 29/1,
Yes,
2021. That is a matter which should be, exactly, it has to be brought on record in 7477, where there are other people involved.
yes, yes.
The persons who are claimed and been given seniority now pursuant to this.
My lord is
Otherwise, we
right.
Cannot consider.
My lord is right. I will not dispute. That's why I have stated other WP 7477 is pending. It may be tagged to. I am not saying, my lord, anything else. But the question is now. No. Cost cannot be imposed, my lord. But how tribunal can impose cost? When application is filed, it says, my lord, no ground, 1.5 years. It further says, no, we have adjudicated a absorption order in other application. It is not adjudicated. 13/5/21 order is not adjudicated at all. Because I am the respondent, how I can adjudicate it, my lord? I am not the, my lord, the applicant there. No, my lord, tribunal, the government reverted me.
Yes.
But government reverted me based on the earlier order. Is it permissible is the question. But court never said.
An invitation for an option itself is the first question. Unless that is answered, nothing else needs to be answered.
But
Is it, what is 29/121? Is it a further option given to all employees?
all employees, my lord. It is given to all employees, my lord. It is not 371J.
Correct. Where the others are part of it, not. in
Yes,
the-
my lord. Both can be kindly, my lord, tag together. When is it? Tuesday it is coming, I think. My lord, huh? Tuesday. It may be called on Tuesday, my lord. It is coming.
Just along with WP 7477, government advocate to get instructions. Yes.
May I make an appeal to your lordship on 18th or 19th, because reversion is there, my lord. There is no order of reversion.
If the other case is posted, well and good, otherwise we must get that posted.
Hello.
Yes.
Along with that writ petition, this may be, that may be posted along with this writ petition, but
Whenever that is posted.
not,
Yes. This
Because-
is along with 74.
reversion is there, otherwise not, there is, the court never said you revert them. So, referring to that application, Lord,
Reversion is a consequence, counsel. You have been treated as junior, therefore you are reversed. It is a consequence, nothing
No.
can be done.
my lord, question,
Yes,
reversion, Lord, subject to, my lord, say, because there are 2 cadres, my lord, there, assistant executive engineer, Lord, grade 2 and grade 1. Grade 2 are diploma holders. Grade 1 is only, my lord, degree holders. Degree holders are very less there.
please, instructing counsel, move 7477. Yes,
My lord, kindly give one date, not next week, 18th or 19th, 20th, because I'm,
after 2 weeks. Yes.
my lord,
Passed over
met with a
matters,
reversion order.
Seal number 8.
Yes,
First writ petition brought petitioner is the Deputy Secretary of Jilla Panchayat,
who is the appointing authority to the posts of
What were the opposite objections? Only translation. That's fine. Submit. Yes, what is the matter?
petitioner is the deputy secretary of the Jilla Panchayat, who
Hmm.
is the appointing authority for the posts of secretary grade 2 in Gram Panchayat and second division accounts assistant.
Yes.
These two posts are different cadre posts. The in-service candidates to be appointed for these two posts are from among bill collectors, that is one stream, and persons who are working as typists, clerks, and data entry operators. Yes. Data entry operators in Gram Panchayat.
Unions notes, synopsis is
Yes.
Procedure followed is that the Jilla Panchayat used to direct PDOs of the Gram Panchayat to send particulars of eligible bill collectors and typists and other persons working in their Gram Panchayat with all their credentials through executive officer of the Taluk Panchayat. And that has to be forwarded to Jilla Panchayat, that is deputy secretary, who is the appointing authority. A seniority list is prepared of bill collectors and typists and clerks. Two separate seniority lists are prepared. Thereafter, options are obtained as per the circular annexure R1 issued by the government. Since appointments are being made simultaneously to two posts, and for which both bill collectors and typists and both are eligible to these two posts.
Secretary grade 2 also can be filled up from bill collectors, typist clerks.
there are two posts,
Yes.
that is Panchayat Secretary grade 2
Correct.
and second division accounts assistant.
Yes.
For which the feeder cadre are many. That is bill collectors, clerks,
Both the
account
posts.
assistant. For both
Secretary
the
grade,
posts.
grade 2 also can be filled up.
Yes,
Yes.
for
Yes.
both.
Yes.
After preparing seniority list, as per annexure R1, the candidates has to give option whether they are interested in getting appointment to the post of the secretary grade 2 or the second division accounts assistant. All the persons, including the second respondent here in has submitted option. Initially, he submitted option saying that he is interested in going either of the posts. If any post is offered, he is ready to go. Then another consent letter was obtained saying that he is interested in going for secretary grade 2 only.
Hmm.
Then after getting those consent letters, two separate lists from among bill collectors, those who are interested in for bill collector, secretary grade 2, and those who are second division accounts assistant, two lists were prepared. Similarly, for among typists, clerks, and two lists were prepared.
Prepared for each feeder category.
Yes, yes, thereafter, as on the basis of the seniority and roster, selection was held. As per annexure A2, in the writ petition, so far as this writ petition is concerned, it is only for in respect of second division accounts assistant. Annexure A2 is the impugned order, selecting certain persons. This person was not selected because he has not opted for second division accounts assistant. After the process of selection was over, he filed an application before the tribunal saying that there is no the procedure of getting option before making these appointments. Therefore, obtaining option itself is illegal. He is senior most. If his seniority is considered, he is entitled to be appointed as second division accounts assistant. That was his case. This panchayat has appeared, Jilla Panchayat, that is appointing authority, has appeared, filed objection. Thereafter, additional objection. one of the contention taken is that, my lord, he is a person who has participated in the process of selection. Since he remained unsuccessful, after remain unsuccessful, he cannot challenge the appointment on the ground that process of selection itself is illegal.
Process was known even before the selections were made.
Yes, my lord, that is annexure R1. He submitted consent letter also. That I have produced annexure R2. Annexure R1, I take your lordship, my lord, for getting the consent letters.
Page.
Page 33, translation copy, my lord. And page 38, my lord, the Kannada version.
Yes.
Page 33, 11th portion, my lord. Para 4, my lord.
Yes.
The candidate he or she mentioned in the general list shall be eligible to be recruited as grade 2 Gram Panchayat secretary and second division accounts assistant on the basis of educational qualification. But a person who is possessing PUC or 10+2 qualification has to be appointed to any one of the said two posts. A candidate has to be appointed to the post of secretary 2 of the Grama Panchayat or second division accounts assistant as per his choice. There is no possibility of change of post once a person is appointed to one post. Regarding this voluntary consent letter from the candidate shall be obtained. A person to be selected to the post of secretary grade 2, though he holds the qualification of SSLC PUC, he shall put in 10 years of service, and a person to be appointed to the post of second division accounts assistant shall put in 8 years of service. This is 10 years, 8 years, now changed to 6 years. Now, because of this clause, we used to obtain consent letter. He submitted this consent letter as per annexure R2. Next document. Before that, checklist, before at the time of scrutiny of his applications, checklist to be checked, is at
I think we went by the annexure R1, this is pertaining to year 2001. And the CH rows are coming there, this is in the 2022 million. Now they are also reported as per the CH rows of the rules pertaining to year 22. Yes.
When was the selection conducted? When was the selection actually conducted?
Selection conducted 22 million.
Process commenced in the year 2021 itself. Application, the direction for issue to PDOs of Gram Panchayat as per annexure R2, that is R3, in the year 2021 itself.
Yes. As per reference government letter, general list of Gram Panchayat staff, bill collector, come clerk and clerks has to be prepared at the end of 1/1/20. Therefore, it is hereby substance and the information. Regarding publishing seniority list of employees, that is on 2011-21. Prepare and publish seniority list of Gram Panchayat employees who have been serving continuously more than 6 years.
These three dates would clarify that position. 2/2/2021 is the date on which the process was commenced for the selection. Then the draft rules was published on 7/3/2022, 1 year later. Then 1/4/2022 is the final of the rules.
Yes. Yes, please continue.
Yes, then his consent letter, annexure R2 in page 45. Translation.
Yes.
He has not disputed this in the proceedings before the tribunal. Now, tribunal in the impugned order says that this circular, that is annexure R1, there is no mention of our for getting the consent letters. There is no procedure as such. That is, my lord, will get your lordship, my lord, in the impugned order of the tribunal, my lord. Para 20, my lord, ink page 126.
Yes.
It is the contention of the second respondent that while the memorandum dated 11/1/2012, it is stated that the eligible candidate has the option of choosing either one of the posts of Gram Panchayat Secretary Grade 2 or SDAA for appointment, that the applicant, while the undertaking dated nil, has opted to be appointed to the post of Gram Panchayat Secretary Grade 2, and hence he is not eligible for consideration for appointment to SDAA post, for which recruitment was made too long with 3 posts of Gram Panchayat Secretary Grade 2. We have not been shown any provision in the memorandum dated 11/1/2012, that is Annexure R1 itself, regarding calling for any options from the persons in the relevant seniority list for any preference for appointment to a service prior to even considering their cases for appointment. Also, we are also not been appraised of any notification by the second respondent in which the number of posts for which the recruitment is to be made, the source of recruitment, that is seniority list of bill collector or other cadres in Gram Panchayat from which quota the posts are meant have been filled, and the classification of the posts based on the reservation category. Not, this is not totally perverse, because just now I read not Annexure R, which says that not we have to obtain consent letters. Now, by the impugned order, the tribunal has set aside the order. You last may kindly see not the operative portion. Ink page 135, not. The OM dated 25/7/2022 as at Annexure A2, and the consent OM dated 27/7/2022 at Annexure R14 is quashed to the extent it concerns the appointment of the private respondents who are not entitled to be appointed to the post of SDAA with regard to the reservation roster in terms of the seniority list of 15/7/22 as at Annexure A1 and Annexure R7. They shall cease to hold the post of SDAA with immediate effect and shall stand reverted to the bill collector cadre in the Gram Panchayat concerned with immediate effect. The prayer for appointment of applicant to the post of SDAA is rejected. This is without prejudice to the applicant being considered for appointment to the either posts of Gram Panchayat Secretary Grade 2 or SDAA in accordance with the 2021 recruitment rules. The second respondent is directed to review the select list of other cadres dated 27/7/22 as at Annexure R13/16 to be strictly in accordance with 21 rules and based on the seniority list of 15/7/22 as at Annexure R7 and R8 in relation to the bill collector cadre and other cadres in Gram Panchayat respectively, with due notice to the consent likely to be affected. Tribunal holds that since he submitted consent letters, he is not eligible. My submission is, since he participated in the process of recruitment, failed remained unsuccessful, he is not entitled to turn around and say that procedure adopted is illegal. He is stopped from contending the procedure adopted by the appointing authority.
When were the rules notified?
But
The revised rules, I mean,
So that was 7/3/2022.
7/3/20.
2022 draft. Final mallots is on 1/4/2022.
1/4.
1/4/2022.
The notification, notification that has been published on
Oh, this is the note.
11th April 2022. I separately have
The general services. Published as required.
Which is introduced for the first time, not an amendment.
Yes, my lord. First time.
First time.
Prior to this, my lord, he himself, my lord, in 2012 itself, he has submitted consent letters. Follow, annexure,
That was the OM in 2012.
Yes,
by
yes.
which it was being conducted.
Yes.
This comes up for the first time only
Yes.
once it's notified. Notification is on 1/4. Notification 31/3. Yes,
Sir. Yes, frame lots, sir. The rules, lots. May not be repeating lots what he has already submitted. Lots, this is a case where lots, the respondent hearing lots was the applicant. He exercised lots the option and thereafter lots. That was considered by the authority. Not having selected lots for the
yes.
Panchayat Secretary Grade 2. Lots, he attacked lots the selection to the post of lots second division accounts assistant.
The numbers would be less in the post of Panchayat Secretary and more in the case of SDA. Would that be correct?
if, my lord, his case is considered for secretary grade 2, his seniority will be 6. That's why, my lord, he was not selected. In second division accounts assistant, he comes little higher.
Lots, having participated lots in the selection process, he acquiesced his rights lots to challenge lots the selection process. Lots, there are two aspects lots. So far as the subsequent rules lots, it operates prospectively unless lots it is specifically or expressly it is provided lots, it would operate retrospectively.
Yes.
But the rules, my lords were to see.
Come into force at once
Yes,
from the date of their final publication.
yes. And so far as lords, there is a distinction specifically lords. So far as the direct recruitment is concerned, lords, this rule says the rules of 2020 lords 2 would apply. So far as lords, the promotions are concerned, lords, it is silent about it. But so far as serial number 10 is concerned,
Yes,
the Panchayat Secretary Grade 2,
yes,
lots is so far as the mode of selection is concerned, lots.
Yes.
Say 1,
yes.
25% shall be lots as per the recruitment
director.
rules 2021.
Yes,
So far as lots the promotions are concerned, lots it doesn't say that it should be lots as per rules 2021. In order to apply lots the present rules.
but it says 75% by direct recruitment of in-service candidates. That is the promotion.
That is the lots.
On the basis of seniority
Yes.
from the cadre
Yes,
with the following procedures.
yes, lots.
In
Not-
accordance with the following
Yes,
procedures.
that is
Therefore,
lots applicable.
whatever is stated here will
Yes,
have to
Lord,
be
that
followed.
would apply, Lord, so far as the promotion is concerned. Lords, my argument, Lords, is of two folds. One is, Lords, that the rules are prospective, and even assuming, Lords, the rules would apply, then also, Lords, it is only applicable to the direct recruitment, not to the promotional posts are concerned. If, Lords, the promotional posts are to be, Lords, brought under this, Lords, it doesn't say anything about, Lords, that the rules of 2021 would apply. Lords, so far as the direct recruitment, it is specifically stated. Lords, even otherwise, my argument, Lords, is that since these rules are prospective, Lords, the selection process commenced prior to, Lords, the framing of the rules itself.
Have to be completed in the course of the.
As per the earlier
proceedings.
rules or the procedures.
Rules can't be changed midway.
The rules of the game, Lords, cannot be changed, Lords, is my respective. Lords, in view of this, Lords, since he has already, Lords, opted for the Panchayat Secretary Grade 2, Lords, there is no question of Lords, he being considered for the post of Lords, second division.
Did you not raise this contention before the tribunal that there was an option provided?
Yes, Lords, that is part of
Of the
Lords,
contention.
Annexure R2.
Here,
No, there is a document itself, Lords, Annexure R2, exercising, Lords, his options. Even the Jilla Panchayat, Lords, has placed it on record by way of the statement of objections.
yes,
Not so far as recruitment, not a promotion post.
Please
Both
wait.
are 50%.
he's not completed his arguments. Please wait.
Lords,
Please don't be in a hurry.
Lords, the another aspect, Lords, is that The kindly see, my lords, what the tribunal has done. But he challenged, my lords, the selection order, that is at connection A2.
Yes.
The tribunal, my lords, goes on further to say that, my lords, the entire the seniority list, my lords, itself is set aside. Thereafter, my lords, calling upon the Jilla Panchayat to redo, my lords, the entire seniority list. And thereafter, my lords, once again, kindly see the operative portion of the order. But if I may
It is
read,
in-
my lords, from
this-
page 38,
Yes.
but internal page of page 24, my lords, last 5 lines, my lords. If any person who has been offered an appointment, my lords, get it, my lords?
Yes.
If any person who has been offered an appointment for any of the posts of SDA or Jilla Panchayat Secretary Grade 2 and rejects the same for any reason, he continues to be in the seniority list and requires to be considered for appointment to any of the aforesaid posts at the next recruitment, since there is no provision in the C&R rules that a person considered for appointment to a post having rejected the same would not be eligible for consideration for the same post in the next recruitment process. Of course, the corollary flowing from the above proposition is that a person who has rejected an appointment to the post of Gram Panchayat Secretary Grade 2 or SDA in a recruitment process cannot be refused consideration of appointment to the other post to which he was not considered for promotion at all in the first instance in his turn during any future recruitment process, only for the reason he had rejected an appointment to the other post on an earlier occasion. It is pertinent to note that where recruitment of two independent cadres are from the same source and based on notified seniority list, the said seniority list is the basis of selection, and those who continue to be in the seniority list have to be considered for inclusion in the select list and offer an appointment made on that basis. It is only after the acceptance of the offer of appointment on the basis of inclusion in any select list that the person concerned ceases to be born in the seniority list and not available for selection. In terms of the rules to 2021 rules, as long as a person is born in the seniority list, he has necessarily to be considered for inclusion in the select list in respect of the post in any of the Gram Panchayat Secretary Grade 2 or SDA cadre for which the recruitment is held. There is no provision in the rules to prepare a seniority list based on option secured, though through the process not specified in the rules, and which leads to a situation when the process prescribed in the rules itself is subverted. The reliance placed on OM dated 11/1/2012 as a annexure R1 does not authorize any such procedure for preparing seniorities comprising only of persons who have expressed explicit option for being appointed to any specific cadre. There is no specific methodology prescribed for obtaining such options, as well leading to a situation in this case where preference is considered as a. In view of the discussions above, the application partly succeeds, and we summarize our conclusions as follows. OM dated 25/7/2022 at annexure A2 and consequent OM dated 27/7/2022 as at annexure R14 is quashed to the extent it concerns the appointment of the private respondents who are not entitled to be appointed to the post of SDA. With regard to the reservation roster, in terms of seniority list 15/7/2022 as at annexure A1 and annexure R7, they shall cease to hold the post of SDA with immediate effect and shall stand reverted to the bill collector cadre in Jilla Panchayats concerned with immediate effect. The prayer for appointment of applicant to the post of SDA is rejected. His claim, lords, is rejected. This is without prejudice to the applicant being considered for appointment to either post of Gram Panchayat Secretary Grade 2 or SDA in accordance with 2021 rules. The second respondent is directed to review the select list of other cadres dated 27/7/2022 as a annexure R13/16 to be strictly in accordance with rules 2021 and based on the seniority list 15/7/2022 as a annexure R7 R8 in relation to the bill collector cadre and other cadres in Gram Panchayat respectively with due notice to the concern. But virtually it has gone beyond the scope of lords the proceedings and calling upon lords the authorities to review. The tribunal mainly proceeds, my lords, that 2021 rules would be applicable, whereas, my lords, the process of selection commenced, my lords, in the year 2021. In fact, my lords, this annexure, my lords, Lords, Annexure R1, page 68, Lords, that is 11/4/2012,
Yes,
which provides, Lords, for obtaining options or
yes,
exercise of option. But this was not challenged at all. This was, Lords, holding the field till 2000, Lords, 21 rules are brought
yes.
into effect.
When the
Yes.
rules were published, the list was prepared, seniority list.
Lords, it was, Lords, earlier, whatever, Lords, seniority was there, based on that, Lords. In fact, Lords, kindly see Annexure R1 also. That is the communication made. By which, Lords, based on the seniority, Lords, page 85,
Yes, it was earlier.
Annexure R3,
It's earlier.
that is 2/2021, Lords. The, based on the seniority list, Lords, the communication was made. That is
Yes.
as on 1/1/2021.
Yes,
Please.
yes.
Lords, I
What do you
have,
say?
Decisions, Lords, on the point there.
Please. Yes,
The post of Secretary Gram Panchayat Secretary 2 and second division accountant, which will as per the seniority list prepared on the bill collectors, clerk cum accountant mirror. The rules mirror, it is not a promotion post. Both are direct recruitment. 50% recruitment from the among the other recruiters, and
Yes.
50% among the bill collectors and so mirror.
50% in-service director.
In-service candidate.
Hmm.
He is the senior, there is no dispute, I am the senior more than the private respondent. I was told he is the serial number 6 million. And senior role 10, 11 and 15, the private respondent, this is in the writ petition. Second, they are the private respondent, they are the juniors to me. The senior, the list, the selection list has to be prepared as per the CNR rules of 2021. The 2020 law is clearly stated that they have to prepare two separate lists. And before preparing the memo, they can't take a consent memo. The consent memo, earlier it was consent, and the rules are enacted in the year 2021. They abide by the rules as enacted in the 2021 memo. The circular memo is pertaining to year 21 or 2012 memo. What are the dates stated in memo? The consent taken, the consent is not necessary. And the tribunal clearly had the page number, import not page number, in the petition, page number 135.
When are the rules of 2021 rules as it's, when are they operational?
They are operating in the 2022 mega.
33, 2020.
The rules of they shall be able to post in the level of their final publication in the official gazette. The official gazette is published on 11th April 2022. Rules are came into effect from the 11th April 2022.
Therefore, the contention is that the entire selection having been initiated long before. Before 11/4/20.
Because on the date of commencement, there is no rule. They have to abide the rules.
There is a executive order. So long as
That
so long as the rules have not been brought into force, whatever are the executive orders.
they can't go beyond the rule, my lord. They can't recruit the rules beyond the rule published, my lord.
Council, it is only after publication that the rules become operational. Till the rules become operational, the office memoranda or the executive instructions are applicable. That is
They are applicable.
the settled principle.
Saying that the commencement is started in the rules, it's not wrong.
Then when did the selection commence?
Annexure A to me.
25/7/2020.
Yes, 25/7/22. By publication of after the CNRs, after the publication of CNRs.
But this is appointment order.
Yes, well, appointment, they commence in Millard. After the publication of the seniority law, as per annexure A1, the publication of the seniority rules is published on 15/7/2022.
When the selection process commenced,
Process, they have to commence the process after the publication of final seniority.
date.
When,
Then,
when did
You have
the
not mentioned.
process
the reason you
commence?
have not mentioned.
That is the crucial date, Council, and without that, how can we decide this? When did the process commence?
No, they have to state, the Jellapati has to be there, when they have started the process. They have to point it out.
You were the applicant before the
Yes,
state
before my-
CH. What
my
was
con-
your
Yes,
contention?
my contention, I am the senior, than the private respondent. Instead of selecting me, they have selected the private respondent. And my seniority is stood at serial number 6. They are stood at serial number 10, 11, and 15. And what are they contained in the consent is given. The content is pertaining to year 2012, the circular is not applicable to this recruitment.
What about R
Which is
two?
why KT has given the findings that there is no such rules.
What about R two?
R2 is pertaining to year 2012.
R two?
Yes, and it's even. Is number. Page number 26, madam. Sir, R2 does not promote any date, madam. That is consent letter. R1 is a circular, madam, official memorandum. That is pertaining to year 2012, 11/4/2012.
R2 is your letter.
R2 is my letter.
You
But
should-
it's,
you should-
doesn't have any-
You should tell the date.
You know when the date was?
There is no date.
You should,
Earlier,
tell-
earlier in the-
no, there may not be date, but you must be knowing as to when you presented it.
Yes, madam. This rules, madam, what is stated in the official memorandum is not, does not applicable to this selection because it is pertaining to year 2012. Even though there is a mentioning in the consent
Rules-
is necessary.
Rules came into force in 2022. Before that, there was some procedure in place.
No. They have to abide by the CNR rules as per the 2021 rules, madam. The rules have, the term looks up to taking the consent.
How can they abide by the rules which are not in force? When was the consent obtained from you?
There is no mention of the date.
No, it is your consent. You should tell.
No, earlier also, my lord, they have taken either of the post, my lord. Current, when you see the annexure. Annexure A5 and A6. In the year 2012, when this official government is operating, my lord, on that occasion also they have obtained a consent letter. On that occasion, my lord, we have to choose either secondary grade 2 or SDIA. Page number 34, madam, in the first petition. First petition, page number 34. Is in Kannada, madam, what is the translation copy in the page number 54, madam.
Second division.
Sorry, page number 24. Page number 24.
Oh.
Translation copy.
The grade 2 Gram Panchayat PDO.
Which means it did not exist.
A2 in annexure, in annexure A5,
A5.
What
Yes,
you are-
that has been,
no, what you are saying is- what you are saying is either of the post.
Yes, but earlier either of the post.
Do you have a case that you did not submit R2 option? Did you have a case before the tribunal that you did not submit an option?
No, option is not necessary. Option is not necessary.
Question is
That's
not
not
whether
the-
it is
the-
necessary
it has
or not.
given the findings.
Please answer the question, Council. Did you have a case before the tribunal that you did not submit such an option?
No, I am not subject, my lord, but they have produced the consent letter for which year it is produced. There is no date.
No, rejoinder is filed, not disputing that letter.
Yes.
Moreover, the recruitment process is not a regular recruitment process, my lord. They have contended that you have participate in the selection post, and if he is not selected, that's why he approached the KIT. But this is not a correct, my lord. This is not a process of regular recruitment. Since among the.
Whatever be the recruitment, the question is whether the procedure was known.
Yes, ma'am. Procedure is pertaining to year 2012 only. Subsequently is not coming the picture. Ma'am.
Yes, we consider. Yes, what do you say?
And the findings of the KIT, madam, just I will.
Yes,
Page number 135
yes,
in the first exhibition, madam.
yes.
Report order. It is coming from the third line, madam. Third line. Page number 135.
Yes,
There is no provision in the rules to prepare the seniority list based on the opinion secured by the, secured to the process of, not specific to the rules. And which leads to the, to a situation when the process of prescribed in the rules itself is subverted. The reliance placed by on the, OM dated 11/1/2002 at Annex R1 does not authorize any such procedure for preparing the seniority list, comparing only on the person who have expressed split opinion on being the appointed. There is a finding.
Finding is contrary to the OF, that's what he says.
Yes, my lord. This is finding, my lord, contrary, but what is the document is pertaining to 2012. Before the CN was come into post.
yes, we understand. We'll consider. Yes, yes. There is an OM. That OM provides for the process of selection. All this is admitted. The OM also provided for separate lists to be prepared in respect of the two posts on the basis of options to be submitted. Therefore, the only question would be whether the OM is applicable or the recruitment rules are applicable. The rules have come into force only on 31/3/2022. If the process of selection has been initiated earlier and only the appointment remains to be made after the rules have come into force, the earlier OM has to apply. Therefore, this judgment has to go, it has to be sent back for a consideration as to the, what is applicable is it 2012 rules. The 2012 rules appear to have such a provision for option. Therefore, the fighting is wrong.
May I submit, my lord? The what is the 2012 official government is there, my lord. This is not applicable because, my lord, they can't start the process of the selection, my lord, beyond the commencement of the CNR rules.
Is that the
This
provision
CNR
of
rules
law? Is that the correct position in law?
They have to appoint the as per CNR rules only. What is the CNR rules said, my lord? They have to go by the CNR rules. How can they can relate, my lord, the option government pertaining to year 2012, taking consent of the particular employee.
Now, you should point out that these rules are also applicable to the selection process which has already commenced. How do you say that?
No, they have to point out, my lord, when the selection process is commenced. The ZP has to be stated, my lord.
The process of appointment was coming that Jilla Panchayat has to say, when it is the process. On the basis of that, 2022 will be applicable prior to earlier notification.
It is everybody's agreed case that the 22 rules, 21 rules as they call it, is applicable only from 1/4/2020 or 11/4/2022, when it is notified. Before that, it cannot be applicable. What has happened after 11/4/22? Only the appointment. If that is so, that is the end of the matter. If all that remained to be done was, there are decisions of the apex court. The earlier decision was to the effect that if a procedure starts and then the rules change, everything that is, all the vacancies which were available, the procedure which has gone on, everything has to go on according to the old rules. And only those vacancies which arise after the new rules come into force can be filled up in accordance with the new rules. That was the position. There, if I remember correct, sometime in 2021 or 22, there has been a little rethinking in the sense that if the recruitment has not gone on to a large extent and there is a change of rules which go to the root of the matter, then probably it is not a procedure as to how selection, the very feeder category changes or something dramatic happens, then with regard to the filling up of the posts, if the procedure has not gone on too much and the examinations are all to be conducted there, then you need not look at the old rules because the new rules have already come into force. Here is a case that after the coming, it is only on 11/4/2022. By the time everything, if everything has been done and all that is required to be done is the appointment, then definitely the old rules have to be looked into. It is not as if the old rules have no force. Until the new rules come into force, that is a settled position of law. The old rules, the executive directions have to be complied with. The executive directions, in as much as there are no rules in force, will have the force of the rules. That is the. Yes. Specifically tell us when did the.
Lord, it commenced as per Annexure R3 from 2/2/2021.
Okay. And what was the stage of the rules when the other rules, I mean, the stage of the selection when the rules came into force?
By that time, Lord, the process of this preparing seniority list, Lord, was over.
When was R2 submitted, according to you?
R2 was submitted, Lord, through executive officer, Lord, to the Jilla Panchayat, Lord, prior to that, Lord. Subsequent to that.
After the initiation of this selection process?
Yes, Lord.
Yeah, Lord, so far as Lord's the earlier selection process is concerned.
Yes.
Lord's, in my writ petition, Lord's annexure A5, that is for the period 2012.
Yes.
And for 2017, Lord's, I have produced the option, Lord's, exercised by the respondent here.
Yes.
Then, Lord's, certainly it will not be, Lord's, for the period 2012 or 2017. That is for the present, Lord's, selection.
When you produced R2, you say as on what date it was submitted? You produced R2 before the.
Yes, Lord.
Did you say when it was submitted?
Yes, Lord. That is ink page 37, ink page 36, Lord, para 3 of my first reply statement.
Yes,
Lord,
yes,
5.
yes.
Respondent number 2 has taken steps to fill the vacant post in the
Yes.
cadre of second division accounts assistant. Government issued official memorandum date 11/1/2012, under which guidelines were laid down for filling the post of Gram Panchayat Secretary Grade 2 and second division accounts assistant marked as annexure R1.
Just a moment, they created the problem. Please see what they've stated. They created the problem. The government issued official memorandum dated 11/4/2012, under which guidelines were laid down for filling up the post of Gram Panchayat Secretary Grade 2. This was the pleading. And second division marked as annexure R1. As per the said guidelines, the eligible candidates had to submit their option. R1 is dated, it is not 11/4/2012. I'm
Yes.
sorry. Yes. I thought it was 11/4/2012.
Annexure R2 is the copy of
Yes,
this
yes.
declaration.
Accordingly, the applicant himself voluntarily submitted a declaration dated nil, opting to be appointed to the post. No, what was your contention to this? Did you say that it was not submitted in this selection?
No rejoinder is filed.
There have you stated that you did not submit, R2 was not an option submitted by you in this selection?
No, I have not stated by. Because my lord, the consent of letter taking the as per the 2012 official momentum. So subsequently, the CH rules came into existence.
This is the question.
Yes, ma'am.
It cannot be relied upon. Which are the decisions that you are relying on?
Lord's,
Have you taken these decisions with
Yes,
regard to
Lord.
the?
Lords, the first decision, Lords, is
Yes,
the selection process, Lords, is commenced.
yes,
The same shall be, Lords, as per the existing rules, Lords. That is
Yes.
para 11 and 13. Para 11 and 13. I will not be reading, Lords.
yes,
Then, Lords, at page number 13,
yes,
2020, 20 SCC, page 680, Lords.
yes,
That is taking the very same, Lords,
yes.
position in law. Para 15 and 19, Lords.
Here advertisement issued on 21/12/2018. Norms were 2010. 2019 procedure which came into effect from 1/4/2019 cannot be followed.
Yes.
That is paragraph?
Lords, para 15 and 19, Lords.
Yes,
Lords, this page 19, Lords, P. Mahendran's case, Lords,
yes,
has been reiterated, Lords, followed in many other cases. Para 4 and 5.
yes,
Then, Lords, the rules of the game, Lords, cannot be changed. It is at page 32, 2013, 4 SCC 540.
yes,
Para 7, Lords, 10 and 15.
This question is referred to larger bench. Here,
Please.
in Tej Prakash's case, the Supreme Court says the phrase rules of the game cannot be changed after the game has begun, cannot be read like a statute.
yes. It will have to be considered in the facts of the
Yes,
case.
yes.
Yes,
Not saying-
in some cases, it has also been held where the UGC norms were made applicable.
Yes,
Held that that does not amount to changing the rules of the game.
Yes.
In the midst of the
Yes.
selection.
Lords, so far as that, my Lords, proposition is concerned,
One of the judgments are taken a different view.
Yes,
Lords, the page 30,
yes,
so far as, my Lords, method of selection, my Lords, is concerned, it can be supplied by the executive orders, my Lords, is the, in
Yes,
Karnataka,
yes.
this case. Lords, then, Lords, at page number 67,
So that-
Lords, having taken part, Lords, in the selection process, he is stopped, Lords, challenging the method of selection. Lords, that is para 15 and 16.
Yes,
Then, Lords, page 92. In SBI versus James, Lords, acquiescence estoppel, Lords, is considered. Para 14, Lords, is the page 92, para 14. Lords, your Lordships pointed out, Lords, that there is some
yes,
subsequent decision.
yes.
Lords, that is 2023, 3 SCC, page 773.
What does it say?
That pertains to, Lords, the vacancies arose
Prior.
during, Lords, prior to the rules or after the rules. Lords, YV Rangaya's case, Lords, that is subsequently diluted, Lords, to say that the authority can decide whether it should be under the old rules or under the new rules. So, but so far as, Lords, the process of selection once begun, Lords, then it has to be completed. That is the, Lords,
That has not been diluted.
that has not been, Lords, touched.
Just find out whether any judgment is rendered by the larger bench. This is referred in 2013 itself. Page number 32, Tej Prakash Patak case.
Please, Lords.
It is referred to larger bench in 2013.
Yes.
One more submission. The respondent, private respondent, they never appeared before the court. The mark of proceeding, in the fragment of the proceedings, they are appeared. They are appeared through the advocate, but they have not made any written statement opposing my application. They have not made any written statement. And more and more in the repetition, they stated that they have not considered any ground urged by the private respondent. There is no such written statement. They have not made any written statement before the tribunal.
Yes,
Yes, my lord, they have stopped from arguing before this one and filing the expedition. Expedition is not maintainable. Filed by the private respondent.
So far as the rules of the game is concerned, Lords, subsequent decision is also in 2020, 20 SCC 680.
yes,
That is, my Lords, in Assam Public Service Commission versus Pranjal Kumar Sharma. And subsequent, Lords, there is also one more decision, 2020, 4 SCC page 7.
yes,
The credits man, the repetition, para 6 million, para 8, page number 8. The order of the Karnataka State Legislative Tribunal is wholly erroneous and without properly considering the ground pursued by the petitioner. They have not at all filed the requisite statement. Let him show my lord, the file the requisite statement.
Will that preclude him from filing a writ petition if he is aggrieved by the order?
No, they have not contested, my lord. They are not contested by the filing.
They appeared and argued.
No, argument is not taken place. Only by the Wakalat.
Yes.
No, they can raise the contention based on your pleadings.
Yes.
Seniors may not have placed on record of the synopsis, if you can take.
Yes.
So number 12, Jairam Mohammed.
Hearing for the petitioner. I'll not take more than 10 to 15 minutes of your lordship's time. Good time is up. If your lordships permit me, I'll argue today. Otherwise, it could be I don't Tuesday. I'm ready with the matter, my lords, because we insisted for Passover. Therefore, subject to your lordship's convenience.
What is the matter about?
Lords, cancellation of in-charge arrangement of the private respondent, and I was appointed to that place. I took charge. Private respondent will go to the Honorable Tribunal on an interdepartmental communication, even without awaiting an order to be passed on that communication. Tribunal says it's actionable. The subsequent communication, which is actually addressed to the applicant therein, is not held actionable. Insofar as that relief, it is dismissed. Insofar as an interdepartmental communication, it would say that is actionable, allows the application, imposes costs on me, directs the department to conduct inquiry, holds that I'm a public usurper of the office. Therefore, I'm before your lordship's rulings. The urgency is that the petitioner is due to retire in the month of October. Therefore, for some time.
You are the senior hand.
Yes, my lord, I am the same.
Communication.
And my lord, I was in charge, my lord, from 2023. Now, all of a sudden, my lord, that communication came and my lord, they disturbed my position. But as a matter of policy, my lord, I am entitled to continue. And without my lord giving any opportunity of hearing or any natural justice, they made some stigmatic allegation and passed an order, my lord, asking me to go back and the next person who is in seniority is asked to be in charge. I have been, my lord, rendering service from 1.5 years.
Therefore, all of you are unhappy. Everybody seems to be unhappy.
That is why, my lord, one more matter is pending on this issue. The very policy issue is, my lord, questioned there. The lordship may take it up along with that matter.
The policy with regard to
My lord, the in-charge arrangement, only in-charge.
seniority.
In all first grade colleges,
There is
no
no regular.
permanent appointments are being done. This is, my lord, from so many years, my lord, it is in practice. You have annexed to one policy or, my lord, a guideline issue.
There is a rule with regard to how the post has to be filled up.
They say, my lord,
Certifications are
there are
prepared.
circulars, 2 circulars. my
That
lord,
is all. Only circulars.
Rules, they are not giving it.
Lord.
Nobody is questioning also, my lord, that is the fact. But now, my lord, this is the policy and questioning the same, my lord, there is one more petition. That is, my lord,
Let's-
the tribunal has directed, my lord, the senior most to, my lord, grant the in-charge principal post. That is also called in question. Therefore, my lord, anything that happened in this matter or that, my lord, has got bearing.
My lord, in my respect, that is not connected to this, my lord. That is not a policy decision. That's a circular which would say if the current principal retires or superannuates or is removed from service, the next professor, whoever is in charge, will be appointed as in charge. It does not, that's not the method of recruitment to the post of principal at all.
Method of appointment. according
That's
to-
just for the department would say, my lords. Till today, no rules are.
Is there a method of appointment?
Yes.
The appointment is by direct recruitment. That is all. Therefore, from in-service candidates also, you can directly recruit. That is.
There are CNR rules in the department, my lords, which would provide. Yes, my lords. But here what has happened is the there was an incumbent principal, my lords. He retires on one given day, my lords. He would relieve himself and say, since the private respondent, the applicant is the next senior most, he simply hands over the charge. And the order itself says it is tatkalika vagi, temporary, my lords. There is no substantive right granted to him. It is not an OPG basis. It is not a Rule 32 arrangement.
Not by the appointing authority.
No, my lords, that's not even, that order is passed by the principal himself. He would say,
It is by the principal.
it is by the principal, my lords. That is undisputed. Annexure A1, the right on which he's claiming to hold the post of principal is only on the basis of Annexure A1. It is signed by the principal himself. He would simply say, today I am retiring on the verge of superannuation. I hand over the charge to the next senior most professor. That is the applicant. It does not create any right. It's not by the competent authority. Now, the tribunal would allow his application on the ground that when I am appointed, there is no order of the competent authority, without first seeing whether there was an order of the competent authority for the applicant who is appointed.
Held against him. What is held against him?
My lord, a order has been passed. They say it is intra-department coming. No, my lord, it is a order by which, my lord, they made some stigmatic allegation. And they say, my lord, the charge has to be handed over to next senior most. As on today, my lord, I am the senior most. There is one more person. But she said, my lord, I will not be accepting the principal post. She has waived off. Even when this order is discussed, she said, I don't want the principal post. But today, my lord, I am the senior most and I have been doing it. But by virtue of the impugned order before the tribunal, my lord, the stigmatic order, my lord, disturbed my position as a principal. As on today, I am senior most and I have been rendering the service. All of a sudden, my lord, because of the direction from CM office and also a complaint from the.
Who appointed you?
My lords, even before the appointment could be made, the applicant would approach the tribunal. My lords, I'll make my submission only for 2 minutes, my lords. The impugned
Yes. Yes.
impugned communication is Annexure A18. It is addressed by the CAO to the Joint Director, stating that there are allegations against the applicant of non-disbursement of SC/ST funds, and 2, that the applicant is involved in certain political activities which amounts to a misconduct, and they don't even take my name. They would say, place the next senior most professor as the in charge principal. That is only a communication. That is that. My lords, let me complete, my lords, with great respect. With great respect, my lords. This is dated 9th of February, my lords. This is not even addressed to the applicant. I don't know how he gets a copy. Now he gets a copy only on the next date, which is 12th of February. He challenges that also. That is only a simple communication saying that this is the order passed, this is direction issued. You are directed to hand over charge to the next person, my lords. Now, immediately on the same day, 12th of February, he goes on leave for 2 days. That is 12th and 13th, my lords. Of course, someone has to take charge of the in-charge principal, even because there's no one to hold the post of in-charge principal. On that basis, I am the next senior most principal. I take charge. Even before there's an order passed by the competent authority, the applicant would approach the honorable tribunal. Tribunal would not only grant an interim order of stay, would direct review of all those actions which I have taken in those 2 days as in-charge principal. Challenging that, I am before your lordships. Earlier occasion, this honorable court sets aside that order, remands it back to the honorable tribunal. Tribunal would say, just 1 minute. Tribunal would say, since our findings on the interim order are not set aside by the honorable court, those findings continue to be valid, and we will not touch upon those aspects. When we had raised all those contentions again, because this honorable court remitted the matter back to the honorable tribunal to reconsider afresh. Tribunal in the impugned order would say those findings are not set aside by the Honorable High Court. Therefore, we will not diverge or take a different view from those findings at all.
Yes, what was the reason? Is it true that the senior is always normally the senior most person? Yes. Therefore, for the senior who was holding charge to be overlooked and somebody else, there must be some reason. Should there have been an order? Should not there have been an order? Does it operate on these interdepartmental communications? Exactly, he was holding the charge. He was holding the charge. As on that date, for him to be divested of the charge also, if you're admitting that it is the policy of the government that the senior most is to be appointed, should there not be an order?
Yes. So what he has today called is passing of an order. What he has stalled is the very issuance of the order. Now, pursuant to the impugned communication, which is challenged, would be a consequential order appointing me to the post of principal.
Without such an order being passed.
Yes.
To assume charge.
My lords, he went on leave. For 2 days, he went on leave. He did not even place that. He does not even place that on record before the honorable tribunal. He does not even say that he's on leave. For
I gave charge to the next person.
I will
and
not
he
take
assumes
charge.
charge without any order.
I will not take.
He only says it's inter-department communication. And he assumes
Can I
charge.
take charge?
yes,
And when serious allegations are made, stigmatic allegations, without hearing me, without providing opportunity.
Would you allot?
It should have been done in compliance with the rule 11. It's a major penalty charges they have. to
Would
put.
you
And
allot
They are
it?
not the disciplinary authority. The person who has passed the inter-department communication, whatever he says.
Now, what is the position?
Would you allot this permit?
One,
Would you allot this permit me to say this?
And my lord, so far the direction given by the, this on the, my lord, the tribunal, but I have undertaken not to precipitate the cost and other aspects. It was heard and this order was passed.
Just a moment. Yes.
I don't think, my lords, this matter needs to be heard in so much detail. Today, what is stalled is the passing of an order by quashing of a communication. All that I'm saying is, I cannot go and take charge without an order. Unless there is an order passed, I cannot go and take charge. I'm giving that undertaking. He will continue. But today, what he wants to do is, by projecting as if I have taken charge, he wants the communication to be quashed, which is not permissible, is my respectful submission. All that I'm saying is,
19.
Section 19, what condition of service, what order? I ask myself, all that I'm saying today is, let him continue as principal, in charge principal. If there is a valid order passed in accordance with law, only then I can take charge. The communication can't be quashed is all that I'm, my lords, making my submission. If A19, which was communicated to him, is not quashed, A18, which is admittedly interdepartmental, could not have possibly been quashed by the tribunal at all.
But it is not an inter-department communication. It is an order. It has caused prejudice and also my lord, affected my rights.
Unless it is communicated.
Please show us what is the.
My lords, I have produced the translations also.
It is at page 8, my lord, annexure 92 in the Kannada version, my lord. Annexure A18. Lord, his translation, my lord, page 26.
Please give us the administrative tribunal's act also.
Please.
My lord, each page 26, my lord, there is the impugned order.
It is in a letter to and from is there.
Maybe, but there are, my lord, allegations made and my lord, stigmatic and affected my right. But this allegation of SC/ST, my lord, fund misappropriation pertaining to the earlier principal's tenure, not to my tenure. In fact, my lord, I have taken action against this. I have issued memos, my lord, I have ordered for inquiry, my lord, I have made correspondence. This, my lord, the allegation pertaining to earlier, my predecessor.
When is as per circular of this office intimated to them? The senior lecturer.
But the
Direction is to hand over the charge.
yes, my lord.
No.
Specific, my lord, the direction is, the principal of the college is speaking about the politics, election results violated, my lord. And the Karnataka.
Where is the
Civil
original?
Service
Original.
2021, Rule 3 clause 2, 3 and 4, 5. Hence, as per circular of this office, intimated to hand over in charge to the senior lecturer who is senior in service,
Who is directed? Who is directed to hand over the charge?
Yeah.
Joint director.
To the joint director to take action. I mean, I'm sorry for translation, but your lordships can have 92 if I'm wrong. Page 92 in the original paper book. To take action to hand over
Officer writes this to the joint director. Pursuant to this.
with approval of commissioner.
A90. Now, this has been communicated by A19.
Again, direction is given to give the charge to the senior most.
Yes.
And this letter is addressed to,
Correct.
letter is addressed to joint director.
Allegation regarding my lord major penalty which can be imposed. Rule 11 should have been complied.
We have to.
Administrative.
But this rule 3 plus 1, 2, 3, 4, all these are major penalty.
No, no, no.
Unless rule
Conduct.
11 is complied.
It is.
Supreme Court is also.
Unless that happens, what is,
Section
can be
19.
challenged? What can be challenged before the tribunal?
Section 19. May I read, Manoj?
Yes.
Section 9, applications to, subject to other provisions of this act. A person aggrieved by any order pertaining to any matter within the jurisdiction of a tribunal may make an application to the tribunal for redressal of his grievance. Explanation. For the purpose of this subsection, order means an order made by the government or a local authority within the territory of India or under the control of government of India or by any corporation or control. B, by an officer, committee or other body, agency of the government or a local or other corporation. Every application under subsection 1 shall be in such form and accompanied by such documents and other evidence. So what can be challenged is only an order. And admittedly, it is an communication, and the tribunal would also say it's an communication, but would come to the conclusion that in my reply, I have referred to it as an order, and therefore it is an order. I'll show that finding where I say, where the tribunal says they extract my reply and say, even you have referred it as an order, and therefore we'll hold it as an order. That's all that he had to establish. What was the right he had? What is it that is disturbed? And tribunal also says there is no order passed, and therefore there is no cause of action. I'm giving an undertaking before your lordships. In fact, in his pleadings, he would admit on earlier instance, paragraph 2 of his application, he admits when he went on leave, he gave charge to me. So that is only a normal routine. So today what he wants to do is project this communication and say, I have taken charge on the basis of this communication, which is not correct. I have taken charge because he went on leave. I am giving an undertaking before this court. I am giving an undertaking before this court that I will not take charge of the post of principal unless there is a legally valid order passed. But the respondent wants to stall passing of an order.
Subsequently, the order is not passed.
No, because communication is stayed and quashed. No order could have possibly been passed.
After this, tribunal order,
During the pendency.
it was
Stayed.
the authority has said to take back the charge. That's the direction.
This is all, no order passed.
No order is passed.
No, no. After that, after tribunal, interim order was passed by the tribunal to the.
Now your only issue is with regard to remaining in charge.
Yes,
Let that stay and let them pass an order,
yes.
whichever
That's all.
way, either permitting you to continue.
Yes.
Not because
Why?
for the reason this may not.
Why?
Kindly see the impugned order before the tribunal. The stigmatic order.
Not an impugned
There is
order.
no suspension, there is no notice. nothing.
Exactly. Therefore, now it is their call whether do they want to pass an order.
No, that will.
They want-
Because the reason is.
Whatever is the prejudice caused,
How does this,
understand, whatever is the prejudice caused, that will have to be considered once they decide one way or the other, if there is a prejudice. Suppose they say that you are right, you are the senior most, we could not have disturbed you. And they don't do anything further. You are in charge on the basis of the seniority that will remain.
everything here?
Now, the contention is that there is no order passed. And the hands of the government to pass an order cannot be tied. Let them pass an order.
Nobody has said, my lord. Nobody has said they.
Of course they have.
No, no,
Because-
Very well.
not at all.
Let them clarify, let them say order can be passed.
Yes,
That's all.
we'll say that this will not stand in the way of the government taking.
Yes.
Any
Very well.
action. Third, the
Passing an
learned-
order on the basis of AAT. That's all.
Third, the learned council appearing on either side. It is a specific contention of the learned council for the petitioner that that there was no order passed by the government, which was subjected to a challenge before the tribunal under section 19 of the Administrative Tribunals Act. It is submitted that an interdepartmental communication at annexure A18 had been subjected to a challenge which has been interfered with without jurisdiction. Full stop. The learned counsel appearing for the respondent would on the other hand contend that the communication itself was stigmatic and was liable to be considered as an order against him. And that it has caused prejudice to the respondent. We notice that annexure A18 is only a communication from the government to the joint secretary. And that no orders had been passed. It is now the admitted case of the parties that the party respondent is in charge as principal. And that the petitioner contends that he had been put in charge of the post only because the party respondent had proceeded on leave. Whatever that may be, we are of the opinion that by the present litigation, the liberty of the government to pass an order with regard to the respondent as well as the assumption of the charge, but as well as the holding of the charge of the post of principal cannot be stultified in perpetuity. In the above view of the matter, the learned counsel appearing for the petitioner also submits, for the respondent, party respondent also submits that such an intention, that there is no intention to stultify the passing of any orders which are permissible in accordance with law. Full stop. In the above view of the matter, the interim order granted by this court shall stand modified to the extent that the government is permitted to consider the issue and pass orders in accordance with law. Such orders shall not be given effect to and without obtaining orders.
The rest of the order will have to go imposition of cost, initiation of inquiry against me.
The
Impugned order is set aside.
No, not set aside.
the other conditions contained in the order of the tribunal, including the imposition of costs as well as the
Direction to initiate
direction to
inquiry.
initiate disciplinary proceedings shall stand stay.
Please.
That is not your intention also.
No,
That is not your intention also.
Your lordship is disposing of.
No,
No, then, my lord, already there is an interim order, my lord. That has to.
we have, yes,
Your
that has been
lordship,
modified.
you have already undertaken not to implement the cost portion.
That has been modified. We modified that.
Great. Sir.
That interim order shall stand modified to this effect.
Yes, my lord, these two, my lord, we have undertaken and accordingly, my lord, there was an understanding, my lord, and the order has been passed after that. But all directions of your lordship have stayed, my lord.
That will not stand in the way of this court passing an order of stay. We have modified that order. Your undertaking is no longer there, but we have stated that those two directions we have stayed. Because we must consider, if as a matter of fact, it was not a usurping of the charge and all that as stated, then it should not work to somebody else's prejudice also. if ultimately they come and say that they never intended to do any of this, and that his taking, assuming charge was only when, because you went on leave.
But because, my lord, I'm continuing as a principal now.
You've been permitted to continue.
That may affect, my lord, because other conditions.
Why? Why would it affect the other conditions? You are we have recorded that you will continue.
Till further order is
Till,
passed.
till the order is passed, even if the order is passed, it will not be implemented unless it is placed before us and we see the order.
Lordship rising. 24 pass over my three times, my lord, your lordship, you have not taken. The simple issue of transfer, my lord. I find vacating a place. She is in at home since February, my lord. Without posting, my lord.
ejectment should, my lord, ejectment, discuss ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿ.